These rather unusual facts give rise to a number of questions of law. Mr. Ivey's argument depended on the judge having found, which he did, that Mr. Ivey was truthful when he gave evidence that he didn't think what he had done was cheating. He considered it to be what he called legitimate advantage play. In other words, he said he was simply being clever and exploiting knowledge which he had and the casino didn't have. Cheating, Mr. Ivey argued, necessarily involves doing something which is dishonest. And, he argued, he was not dishonest because he genuinely thought that what he was doing was legitimate. The legal questions are answered in the court's unanimous judgment. In a fairly brief summary, the answers are these. One, it's probably not true that all cheating involves dishonesty. The runner who trips up his opponent is undoubtedly cheating, but it's not at all clear that everybody would call it dishonest. Two, cheating as a concept in gambling has existed for some hundreds of years. The expression dishonesty, on the other hand, wasn't particularly current in the law until the Theft Act 1968. And there's no reason to complicate the concept of cheating by adding an extra requirement of dishonesty. If all cheating is dishonest, as some may well say, the extra requirement would add nothing. If some cheating is not normally described as dishonest, perhaps like the runner tripping his opponent, then the extra requirement would wrongly take something away from cheating. Three, in this case, what Mr. Ivey did probably would ordinarily be described as dishonest because he duped the croupier into unwittingly fixing the shoe. And fourth, in any event, the notion that a person is only dishonest if he himself knows that other people would think that he was is wrongly based in law. That idea derives from a decision of the Court of Criminal Appeal in 1982 called the Queen against Ghosh. But whereas it has remained the test of dishonesty in criminal cases, that conflicts with the test for dishonesty when it comes up in civil cases, as it very often does. The court holds that the test ought to be the same, whichever sort of court the question comes up in. And on examination, moreover, the reasoning in Ghosh is faulty and ought to give way to the clearer test which is applied in civil cases. The test for dishonesty involves first deciding what the individual knew about what he was doing and about what the surrounding circumstances were, and then, assuming that state of knowledge, deciding whether the ordinary decent member of society would say that what was done was dishonest. If that is what the ordinary person would say, the behavior does not become honest because the individual in question has different or lower standards. So Mr. Ivey's genuine belief that he was entitled to do what he did doesn't prevent it from being dishonest. Quite a lot of confidence tricks, which any ordinary person would call dishonest, involve exploiting knowledge which the perpetrator has and the target hasn't.